Good morning, Your Honors. May it please the Court. Kathleen, Celio on behalf of the Commonwealth. I ask this Court to reverse the motion judge's allowance of the defendant's motion to suppress. Regarding the issue of consent in Nielsen, because Nielsen is a consent case, what makes this different is that Brown was the only person that could allow the police into this room. The defendant couldn't allow anybody into the room. It was only the director or the staff that could allow the police or anybody else into the room. And I think that, shows her control, her joint authority on that issue. I mean, she was the only person, as opposed to the student in the dorm. The rules were set up such that the staff or the director, who had a common and master key, were the only people that could allow anybody else.
Is it your position that the juvenile had no reasonable expectation of privacy in that room?
Yes, I was just addressing the consent, which is a different.
But move to that. Is
yes.
Your view, which means that the police could at any time just go into that room and search him, and he would have no ability to say that's wrong.
That is correct. This is based on the manual and the rules and regulations that were set up in this shelter.
Okay, but if you're right, the consent is irrelevant because it wasn't even a search, because he has no reasonable expectation of privacy.
No, that is correct. My brother has been relying on Nielsen. And I wanted, Nielsen's a consent case. I wanted to just distinguish Nielsen.
My question is a little bit different. Are you going so far as to say that the police can enter this shelter and search that room without anyone's consent, and that there's no ability to move to suppress in the absence of probable cause?
Yes, with the fact that they were allowed in by the director.
No. That issue. If there's no reasonable expectation of privacy, it's no different from leaving your garbage outside for the police to rummage through. It's not a search. Are you saying that this is not a search?
Yes, I am, Your Honor.
Which means the police could at any point in time come in, search that room, and this juvenile would not be able to move to suppress at all, even if there was no warrant and no probable cause.
Yes, in these circumstances, because
even if the director didn't open the door for them.
Well, then
are you saying that the police could come in? Suppose, I think Justice Gantz is asking you about a different case, nothing like this case. Suppose Ms. Brown knew nothing about a gun, didn't call the police, but the police just walked in off the street and went in.
The police thought there was a gun there. The police thought there was a gun there, so they walked in.
But Ms. Brown had nothing to do with it. The director didn't call them.
She didn't let them in.
Well, that's what I was starting with. The director actually allowing them into the homeless to the shelter.
Justice Gantz is asking you a different question. He is taking Ms. Brown, the director, out of the picture and asking you if, without her, forget about this case, can the police just come into the room and search it for a gun because they think there's a gun there?
Yes, because she says there's no expectation of privacy, so it's not a search.
Based on the resident, but maybe based on the agency, Brown would have a privacy interest if she was charged with the gun.
No, she's not charged with it.
Make believe Brown got hit by a car and she was killed before this happened, okay? And the police thought that this kid had a gun in his room.
Yes.
They also think, hey, we've seen the rules and regulations here. This kid has no reasonable expectation of privacy. They kick the door in. Is that a valid search?
It would not be a constitutional search because the defendant doesn't have an expectation of privacy in room 24.
And that's because of the residence manual. That's your position.
That is correct. That a shelter.
It would not be a constitutional search?
Right. It wouldn't be.
It wouldn't be a search because if you don't have a privacy interest, then there's no search.
She said it would not be a constitutional search. You had two negatives.
It doesn't qualify as a search in the constitutional term, in sense of the word.
Because he has no expectation of privacy.
Correct.
And that's because of the residence manual.
Correct.
And what in the residence manual says they have no expectation of privacy?
Well, if you look at the factors that this court looks at in looking at a privacy interest, I think is control and access. And this individual does not have the ability to exclude other people, could not invite in people, could not invite in guests, could not invite in other residents.
But you don't think that living there for 8 months as your only home gives you some expectation of privacy, even despite the manual?
I think I think you can't look at it without the manual.
There are lots of situations where the condition of living somewhere is very tightly controlled. Many colleges say you cannot have guests in your room Many colleges say you cannot have alcohol in your room. Many colleges say you cannot bring food into your room. Many colleges, or other situations, boarding houses, or even in some, not hotel rooms, but rooms that are used for conferences. There's a whole level of restriction. Are you saying that in all of those cases there's no expectation of privacy?
I think it depends. I think it depends on the facts and the amount of access and control that the individual is given.
Well, let's just take a case where the policy is you can have no guests in your room. There's a common room downstairs on the ground floor, and that's where guests to the dormitory come. You cannot have guests in your room. No expectation of privacy in that college dorm?
And do you pay for the dorm? This is what I'm looking at. And you pay for the dorm?
You may be on a scholarship. You may not pay for the dorm. So you've got a different rule for people who pay versus the people who are on government aid.
I think in that case you may have a privacy interest, but in this case, not only could he not allow anybody in,
so we have to determine you can't have a guest and you can't have alcohol or drugs.
And I mean,
no privacy?
I think that, would you have a provision that allows the staff who has a common key to enter and search?
Yes, we've all signed that contract, because that's how we know we can't have guests, we can't have alcohol. We've all signed that contract. Every student has signed that contract. Some students pay for it out of their own pocket, some students have their parents pay, some students have the state pay.
And no one else is allowed in the house? I think then you would get closer to the situation we have here, where
why does that not leave me with an expectation of privacy? For example, in my personal letters, my capacity to be searched?
Because if you're looking at the place and the shelter here, obviously has.
Aren't you just easier dealing with consent?
It is, and I started with that. But I don't think it. I think that the shelter here, there's a safety concern, and that
there was a safety concern in Nielsen. There's a safety concern in dorm